Good evening, everyone. I am Shelley and I welcome you all to the sixth part of the lecture series based on Basics of Criminal Justice System, which is organized by Aiding Hands Foundation. Aiding Hands Foundation is a registered non-profit organization that works for the welfare of the society. Now, without wasting any further time, I welcome our esteemed speaker, Mr. D.P. Singh. We welcome you, sir. Over to
Right.
you.
Thank you. Okay, good evening, everybody. Last time we two lectures were on bail and different aspects of bail, but I've been told that I did not talk about cancellation of bail and also bail during appeals. So, we will talk a little bit about the cancellation of bail. Now, one Guru Mantra for cancellation of bail is that if it is difficult to get bail, it is more difficult to get a cancellation of bail. Because cancellation of bail, you have to either breach the condition imposed on you, or you have to do such act that it should be cancelled, which are implicit or implied conditions, as we have read in 437. That you tamper with the evidence, you influence some witness. So whether they are conditions or not in your bail, but they are implicit conditions, and if you do that, then bail can be cancelled. To prove that is also an uphill task, so it is always very difficult to cancellation of bail. But now it is something which you must understand for cancellation of bail is that there are two things. When bail is wrongly granted, it is an appeal kind of a thing, but there is no such concept of appeal in a bail. So for wrongly a bail, when a bail is wrongly granted, that a prosecution says that it should not have been granted. No, it is wrongly granted. So it's a cancellation of bail of a different kind. It's a cancellation of bail in the form of an appellate, that a higher court reviews the order of the bail, whether bail was rightly granted or not. So even though the terminology remains same as cancellation of bail, but this is the fundamental difference. When you go to a higher court for saying that it was wrongly granted, or if it is granted and you subsequently go that cancel it. So these are two fundamental differences. But in otherwise also, even if once it is granted, wrongly granted also, cancellation becomes that much more difficult. Because even if it is wrongly granted, you will say it will take a lot of time. So you will say whether, during this time I've been behaving myself well, I've been cooperating with the investigation. I have not done anything. The conduct has not been such. It is not unbecoming of that my bail should be cancelled. So that's the fundamental difference. But either which ways, it is difficult to get it cancelled. But this difference you should know. The other is appeal in a bail in an appeal. Now, in an appeal, you have undergone the trial. The appellate court has, all the material before it, the prosecution case, the defense case, and then they know your chances of acquittal and you undergoing sentence, and it has been dealt with differently by. There are many judges who would like to be more liberal in appeal, especially if it is a single bench case, because it is likely to come after a long time. It is not heard because of the uh, volume of cases that a single bench has to, cater to. So usually, a judge in a single bench case would be a little more liberal in granting bail. The division bench is always cases where the sentence is more than 10 years. And it is very rare that it is 10 years plus. It is usually a life sentence that is heard by uh, division bench, unless it is there are cases of NDPS and others where there can be sentence of 14 years, 12 years, things like that, and then they also go before the division bench. Division bench is as such very circumspect in giving uh, bail because the likelihood of hearing the matter is early. It does not take years. The court does make a distinction in cases where they think that bail should have been granted, or it's a good or a bad case, or it does not require too much of a. They can hear it early, so that the period of incarceration is is not much. So bails are slightly tough, or rather very tough in division bench cases, which are sentenced already suffered sentences more than 10 years. But otherwise, it is this. If you go in technicality of it, Kashmira Singh is way back in 1978, 79 said, no, one should be liberal. It cited various cases. It said you can apply for as many bail applications. That was Babu Singh, that you can, after another 2 months, 3 months, 10 months, you keep. But time is also a new ground after a lapse of time. So these are celebrated judgments, and para 2 of Kashmira Singh is elucidated from somewhere, which I don't know how many judgments have must have uh, reproduced that page, that paragraph. Kashmira Singh versus State of Punjab, if you just want to see, though I don't want to insist on judgments here in these lectures, so that you don't focus on case law, you focus on the practicality of the situations. So you must know, irrespective of whatever the law is, it is difficult to get admission, bail application in division bench cases, because you have already been sentenced to a 10-year plus sentence. So unless there is a glaring irregularity, glaring mistake, error of law that you can point out, the court would not normally, indulge in granting you bail. But yes, in a compelling case, the court will give, what they will do is they will hear your case on priority. That's the next best course that you should agree to. And taking these cases to Supreme Court is usually a futility. 1 in 1,000 cases of such nature, you take it to Supreme Court and you may be granted bail. If I can say, Supreme Court itself is guilty of not granting bail in a lot of cases, and by the time they are heard, they are near about serving their sentence. I don't want to go into examples because there are many. So, having done with my remainder of the bail, if there are questions, you can always put, I will answer. But now let us go into investigation. Now, what is investigation? Because the bail is just one of the FIR is filed, registered, case has happened, FIR registered, you've been arrested. That is one thing. But after the registration of the case, it is important for police to investigate the case. Now, investigation is arrest, seizure, search, these are part of the investigations. But investigation essentially is defined as collection of evidence. Now, that collection of evidence is in two ways. It is the documentary collection, it is the collection of material which are important to the case, it is collection of evidence which can be oral, that is various witnesses. Various witnesses will come and tell you. So that is also a part of the investigation, collection of evidence, because evidence can be oral, evidence can be testamentary also. So together, there can be evidence in your favor. There can be evidence which is against you. There is a lot of time the police will try to go either, if they think that they're suspicious about case and they want to not uh, you know basically challan you on this, then they will ignore, or they will they look into the evidence against you with suspicion, and they will focus on all the evidence which is in your favor, because that is in their head should be the result of the investigation. So whatever goes into their head, that this is their perception of the crime, this is how they want to do it. It is the perception of the police officer which leads to the closure report or the filing of a challan under 170, under section 170, which is there are two sections which are precursor to 173. 173 is the final report to be filed in the court. The precursor to that is 169, where there is not sufficient evidence against you. The conclusion is that there is not sufficient evidence, that is closure. 170, that there is sufficient evidence against him, therefore a person final report is for the purpose of facing trial as an accused. So these are the two fundamental differences. So perception of the police officer that they make during analysis they make in the initial investigation, that yes, crime has happened, or and these are the persons who are likely to be guilty, or crime has happened, but there is a lot of suspicion whether these people are not, because either their presence there is suspicious, or their presence is somewhere else, or somebody will say that they had no axe to grind, they were there to help. Well, there can be so many things, but it is the earliest perception of the police which makes them either to register a case, either to file a closure report. Then they will collect all material that this man was saying that he has seen him elsewhere. This man says that this man was there to help him. This evidence suggests that he, at that time, relevant time, his phone was elsewhere and he was talking to him. These are tickets, train tickets or air tickets or something where the person was traveling. The airport shows that he was present elsewhere. If that kind of an evidence is there, then they will see to it. But if there is evidence, like somebody says, no, I saw him, then they will ignore that evidence, because the evidence in favor is so strong that one person saying will not really cut the ice. So in such cases, then the police will go and file a closure report. Now, suppose the police files wrongly a closure report, or the police is, let's say, partisan in that case, and they want to file a closure report. Complainant, what will complainant do? Complainant is not powerless. In that time, if the court, if the police, after preparing a report under 169, want to find a final report under 173 as a result of 169, then they have to first give notice to the complainant that we are filing a closure report. The court will hear the complainant, and if they are not given notice, court also cannot close it. Court will first give the notice to him, and even the court itself has three possible way to deal with the final report. Way back, you find the judgment yourself. I'm not going to say it, but it is 1985. There was a celebrated judgment of Delhi Supreme Court, where the judgment said that whenever a charge sheet is filed, irrespective whether it is closure or for accused, whenever it is filed, at the time of taking cognizance, the magistrate can accept the report as it is, can reject the report completely, and if it is a closure report, he can reject it as a closure report and can proceed against the person. Third, that the magistrate can say, no, I am not satisfied with the investigation, investigate further. So once these three possibilities are there, that is that is the first scrutiny that the magistrate himself can do. But if he agrees with the report that yes, it has to be rejected or it has to be accepted as this thing, then the magistrate will give notice to the complainant, and complainant will then file a protest as that this investigation was not done properly, this is the evidence, this is the evidence, this is further evidence that I had given to him. They have not considered all these things, whatever it is, but there is a provision of a protest application, and the magistrate looking into it can resort to any of those three possibilities which he had earlier. But in a given case, the looking into, if he feels that there is evidence against the person and police is not no more required for this, then he can even take the case as a complaint case and can proceed with it. The complainant can also file separately a complaint and can proceed with it. The conclusion of or the closure report will not come into his way. Then he has to independently on his own in a complaint case will go and fight his case. So the point is that it does not mean that the police has sent a closure and then that is it. Complainant has no rights. Complainant still would have right. Now, the other thing is, as a lawyer, you should know that during investigation there is something called case diaries. There's a provision of 172 CRPC where the police is bound to maintain the case diaries. Now, case diary is something like this. Let me tell you what it is. Anybody who comes to the police station and says something is written in a case diary of that police station. Anybody who is an employee, a constable, sub-inspector, inspector, whosoever, comes to the police station and goes from the police station, records his entry of coming, records his entry of going. Any person who comes with any kind of a report is also reported as a DD entry of that person. Now, you have registered a case. There is an FIR, let's say XYZ FIR. Now that XYZ FIR has an investigating officer. Let's say Ram Singh is the investigating officer of XYZ FIR. So you can always ask questions in your cross-examination later because he is supposed to write it. That's the necessity of case diary, and the court can look into the case diary even if the accused cannot. And that is, whenever he goes out on a particular day, you have to write, I am going at this stage, I allow accompanied by such and such other constables, I am going for investigation of this case, and where he is going to do, what he is going to do is also to be written there. So if tomorrow you know as a matter of fact that I was not arrested on that day or he was not there on that day, you can always get and cross-examine him on that aspect. Even if he does not want to look into it at the time of investigation, the court can look into it. Any such suspicion, the court can cross-check, and that can be favorable to the accused. The use of case diaries is something which is not known to too many lawyers. Not too many people make the best use of the case diaries. In earlier days, what they used to do is they would somehow obtain, I will not use any other word, somehow obtain the case diaries, photocopy of the case diary, and they will exactly know how the case had proceeded, and then they will make their cross-examination accordingly. Now, these days, it is difficult to get the police's visor, and things are not so easy. So these diaries are not given, but you have to be sure about from your client and otherwise that how and when you would like to refer the case diaries to the court and otherwise. Even on a day-to-day, during the investigation, suppose at the time of arrest, at the time of some kind of a search or seizure, these case diaries are brought. The best is that these case diaries may not be tampered. A lawyer must get them signatured, must request the judge at the time of remand that please sign these case diaries. Now, the cross signature would mean that that case diary cannot be then tampered with. Otherwise, there have been instances where they would write the case diaries again according to what the need should be, and change whatever entries were supposed to be changed. And though all the entries would be there, but being in the same police station, sometimes it is easier to do. And there have been so many instances where this has been done. So as a lawyer, you should be very particular to get the case diaries during investigation, whenever remand application is there or any other application is there, some of the other proceedings whenever happen in the court, get those case diaries signed. And if you keep a track on what is happening while the investigation, it will help you to cross examine with their with the for a cross reference purposes in your cross examination. You will find a lot of benefit from of those cross references from the case diary. If it is not there, then the certainly uh, uh, the testimony of the investigating official is suspicious. He can be impeached on that. So once this investigation takes place, I'm going to be a little fast today because there's so much to cover and we have only a few more sessions. That then a charge sheet is filed under 173. Now understand this 173, which is a very important section. First, 173(2) gives a right of a particular, each state, rather today almost the entire country has a particular format. It may not be same, but each state gives a format under which the charge sheet is to be filed. So in a state, you will find a similar kind of a charge sheet. There will be no difference. The name will be given, the name of the complainant will be given, the distance of the police station from this, the time of the report, time of registration of FIR, which may be different at most times. So the distance of the house, the place of occurrence, all these important details are given in that form of final report. Even FIR has a form. These details are there also. But the IO and all others, then there are columns, column 1, column 2, column 30, like that. So depending upon the state, one column will be who are the persons charge sheeted, who are the persons not charge sheeted, then all those charge sheeted persons will be there, who are there but not brought to prosecution. All those relevant details in one or the other column will come. Then it will be accompanied by a list of witnesses and list of documents. Now you will have to see that all witnesses these days, a lot of police officers also say, they write a remark also that this witnesses for this purpose. The purpose of this witness will be this. Though it is not necessary, not many agencies also don't do it, but this has also been done. So you will find if there is a reference that why this witness or this witness is to prove a particular fact is written there. It is only a good thing. It will only help the lawyer to know as to prepare his case accordingly, that this witness will come and he will do only this much. So there is no surprise element. Other thing is that the list of documents will also, you will know that all these documents are with the police, but police cannot go beyond it. If they have to go beyond it, again, it has to be brought. But it cannot be now a surprise. You have to defend your case within these witnesses and these documents. What is against you is the list of those witnesses will have statements, 161 statements. It can be 164 statements also. But the statements of witnesses and the documents together is the case against your client. And your client has to defend that. There may be other things also. You are not bothered because that is what is brought before you. That forms the basis of your charge. The charge sheet needs to charge. Formation of charge. Formal charges are to be framed. Formal charge is something like this. You, XYZ, on such and such date, at such and such time have been seen by to commit such and such crime, and so you also, you so and so again at such and such time also seen to have hit somebody which is under this section. So each section have to be broken, and there will be 10 charges, 4 charges, 3 charges, 1 charges, depending upon the case. There can be number of charges that can be framed. Suppose a person has died, the one charge will be for 302. He also had a grievous injury. He also had a head injury which could have resulted into also a death. And 307, another charge of 302, 307. Then there's a grievous injury 326, it can be 325, or a simple injury which can be 323, 324, but each will be separate. Suppose there's a case of a fraud, financial fraud. They can be cheating, they can be a forgery. So each charge will be separate, right? So then number of sections, each section will entail a separate charge. That charge has to explain why. Suppose the charge is not framed against you, then unless the prosecution understands during the course of their trial that this charge also is made out, if the charge is not amended at any relevant time, then irrespective, even if there is sufficient evidence against you on the file, the court cannot then say that we can punish you. Many a times in appeals, High Court says, oh, you are guilty of this. And the lawyer says, my lord, this was never a charge against me. Then the court cannot amend the charge at that stage. So charge is a very important aspect because you have to answer that charge. As a lawyer, you have to defend your client based on the charges framed against you. Now, though we went again on a different trip altogether, like always, but charge sheet subclause section 2 is all right, but then there are very important clauses thereafter. Mostly people know about 173.8, which is further investigation. Further investigation also has different facets. Can you also seek further investigation after you have the trial has started? The answer is yes and no. Yes, suppose at any point in time you come across a person was outside, he was beyond you, you couldn't have reached to that evidence in the normal course of nature, then that is the test. Then you can tell the court, seek permission from the court, and then do it to that extent. But if the evidence was all available, you did not look into it, and during cross examination the person, the law, you as a lawyer brings out the fallacy of the investigation, then they cannot ask the court, oh, let me also please allow me to get that evidence also, I'll get that evidence. No, if you could not get it, you cannot get it. But before the trial has started, you can, the trial, the investigation can investigate their case even after filing their final challan. And before the case has started, if they get more material, they can file a supplementary charge sheet. Mostly, even at the time of filing a final charge sheet, the police would say that investigations are still on. Just they will leave that option open, mostly only for this purpose. But what is important and that you should know is what you need to get. There is, suppose as an investigator, he has investigated 100 witnesses. In his charge sheet under 173, you see only list of witnesses, only 25 people. Now, can you insist that he investigated or he recorded statement of 100 people? Firstly, you may not know correctly, but even if you are aware of it, the law mandates that it is the wish of the investigator, it is the prosecutor's wish who he wants to depose as a witness. So if you feel perturbed about it, you can bring it in your defense evidence, but not otherwise. They can be a court witness. You can move an application. That is something within your domain. But it is the prosecutors. You can't force the prosecutor to bring all the witnesses. Similarly, there's another subsection which talks about documents. He must have collected any. You must have given him so many documents. He is not obliged to produce all of them. He has a case of his own. He has to prove that case. If he thinks that these documents are sufficient for that purpose, then it is his call, the prosecutor's call. The prosecution is the driver of their case. They can choose their witnesses, they can choose their documents, they cannot be forced by you. Once that is clear, then how do you go about it? As I told you, if the investigation is partisan, you can make an application for further investigation on the basis of material. Because Section 156(3) gives power to the trial court to monitor the investigation. Courts cannot otherwise monitor the investigation, but they can ask the investigators that look into this aspect. You have not gone into this aspect. Now, how he will go look into it, investigators, again, it is investigators' sweet wish. The court cannot tell how and what to do. The court can only raise questions that this needs to be looked into based on these things. And 99% usually the investigator then understands that if the court knows it and the court says it, he better does this job properly. So trust your courts on that. Trust the system that once it is brought to the notice and the court has taken cognizance of such misfeasance on the part of the investigators, the court will insist that the investigator does the needful with regard to such misses that he or something deficiencies that are pointed out that needs to be rectified. Now, many people don't understand that when 173 report is filed, the court has to take cognizance of it. I'm done with 173. You read it, and if there are questions, you can come back. What was essential to be known under 173, I've told you. The court, when it is brought to the court notice, the court can immediately summon the witnesses. Summoning of witnesses are the court, otherwise the court should have gone into it. But if the court just sees it and it has applied its legal mind, that's the test, then it has taken cognizance. Even if the court may not even have looked into it, but if the records gone through, filed, and all accused persons who are summoned, the court has applied its mind. When I'm saying you, most of the times I'm talking about accused. You are always a representative of an accused. So take it. I may be, because when a court says, "Who are you?" I don't have to say I'm such and such. I'm DP Singh, advocate. The court, when they ask you in the court, "Who are you?" you have to say, "I am the petitioner in this case," or "I am such and such petitioner," or "I am accused number such and such." You are then a representative of your accused. So just to case, because many times while saying I keep saying you will be given this, you will be given this, then I mean you as a representative of your client. So now, having taken a cognizance, then what will happen? Then the accused will come to the court along with the lawyer. So you will first think, you will ask the court, "Okay, my lord, yes, my client is here. If he is already bailed out, you will have to again give your bail bonds. When the person is summoned, even if he is bailed out, he will be given fresh summons. He'll give fresh summons. The court may accept the same surety and everything, but these summons will have to be given afresh. Suppose you were never arrested at any point of time, you will be asked to give bail bonds again at that time. So that is the first thing that you have to do is give your bail bonds and show your presence that you are now in the custody of the court. Whenever the court would like to call you, you will come. And if you don't come, the court can insist or can cancel your bail if it feels that you are not going to come and attend the next time also. So if you miss a date, there are provisions. The court can issue a non-billable warrant. Court can give you a warning. Court can even arrest you when you come next time. And then another process of bail will start. But more importantly is that once you are summoned, you have then yield to the custody of the court. The court has now control on your movement, on your freedom. Now, as a lawyer, the next step will be you will say, my lords, I must be given the entire charge sheet. So a charge sheet will be provided to you, maybe on that day or maybe on the date next. Then charge sheet is given to you. It has to be exactly same as is declared, that all the witness statements, how many pages, everything is written. So you will go back, you will see if they are legible, if every document is there, all pages are there, all witness statements are there, there is nothing amiss. If otherwise there is anything amiss, you'll come back to the court, you'll move an application under section 207 for supply of documents, and the court will supply you those documents. Once the documentation is complete, you as a lawyer, you are satisfied that you have all the documents now in your possession. The court will give you a date for framing of charge. The framing of charge would then thereafter would mean that you have to argue your case on the prima facie thing. Charge means that it's not only suspicion, it is grave suspicion. It is more than a suspicion. Then even if there are a lot of other elements which show or which point out to your innocence, the court is bound to register frame charges in that in a scenario like that. But if it is mere suspicion, and there is also a lot of suspicion whether there is enough material which can ultimately convict you, and it is not too grave, then the court at that time can also discharge you after hearing the arguments. So, framing of charge or discharge. How charges are framed, I've just stated a little while back. But this is a crucial stage because when you are arguing, you have to consider two things. Because I was quickly running through the procedure, but now I want to stay a little bit and tell you. See, when you are all lawyers across nowadays, there's more of a fashion that we have to argue at the stage of charge because of number of reasons. One, a lawyer is paid. Two, he tries to tell the client, and the client is also saying, try your best at this stage itself. Seasoned lawyers, seasoned criminal lawyers will say, let the charges be framed, my lords. Please frame the charges. Why? Unless the lawyers have to make money, they have to make a statement of impact, or they have to impress their clients of what they have to do. Charge is a stage where normally, unless you are 500% sure that you have a good case, don't argue. Don't even argue a part charge कि ये बनते हैं इसलिए करवा दो बाकी तो नहीं बनते. This is something that we can clearly get out of it. Don't argue. Why? Because you will open up your defense. The prosecutor will understand that what he has to do to save his case. So they will bring evidence in a manner. You will read 161 statement. This is not there. This is not there. These are the documents which are not there. There are methods where this evidence can be brought and these lacunas can be filled. One is the witnesses then will make improvements, and sometimes subtle improvements, or not such improvements which otherwise should not be read, which would impeach the veracity of the testimony. If it is so subtle, or it's so a little change which is notional, or which is not something which is totally contradictory, but it will do sufficient damage when you have already argued your case at the stage of charge. Let them make more mistakes. Let the prosecution make more mistakes. Remember one thing: the prosecutor's job is the difficult job in the criminal trial. If anybody's job is most difficult, it is prosecutors. He has to prove his case beyond reasonable doubt. You only have to bring a chink in it. As defense lawyers, you have to bring a chink in it. It is the uh, you know uh, responsibility, duty of the prosecutor to prove his case. So it is, let him do his job. All you have to do it every time a person comes. You bring your defense in a manner, you cross-examine him in a manner that it becomes apparent. The deficiency becomes apparent at that time only. And then it becomes difficult from stage to stage. He cannot bring another thing from another witness because you have already put it to another witness. That chink is clear. If you would have argued this at the time of charge, then the prosecutor would bring the first best witness who would say it differently, and you have then little chance for a recovery. A good defense, cross examination, does bring out even then the faults of the deficiencies. But then, it is a difficult thing and it is a risk. Why take it? Charge should not normally be, pursued very vigorously. Uh, Having said that, I believe today I have a heavy day myself. I would rather ask, questions if at all there are. Otherwise, I would like to end a little early today. Sorry, guys, and that is why I had gone a little fast. I would like to, end my session a little quickly today. So, if questions are there, I will answer them. But I'll not take anything new. Next time we will go into the art of cross examination. We'll have a session on cross examination. We'll also have a session on how the trial would proceed. Only on trial we will be focusing next time. So any questions? If we don't have, thank you very much.
Thank you so much, sir, for your enlightened words. The session was very informative. So we are wrapping this session on a very thankful note to you, sir, and all the participants for joining in us. All the participants are requested to be ready for next Saturday's session as well. Thank you so much, sir. Thank you, everyone.